Courtrooms were built for order, but the biggest legal stories often turned on chaos: one missing document, one bad demo, one sloppy sentence in a statute. Subscribe for more true courtroom curveballs, because these 10 wins changed history on pure accident and lawyers accidentally winning cases they had no business winning. Subscribe now and let the next unbelievable reversal autoplay into your feed. Number 10. Murder Trial of O.J. Simpson. Television captured a prosecutor changing the shape of a case in real time. On June 15, 1995, Los Angeles prosecutor Christopher Darden had O.J. Simpson try on the bloody gloves linked to the murders. The risk was obvious. The jury would see either a perfect match or a perfect mess. What happened next became the image everyone remembered. The gloves appeared too tight, and the defense suddenly had a visual argument no chart or expert could outshine. The moment fed straight into Johnny Cochran's closing line, drafted by co-counsel Gerald Uhlman, and it lingered through the verdict. On October 3, 1995, the jury acquitted Simpson. Plenty of evidence mattered, but one avoidable courtroom stunt gave the defense a lifelong highlight reel. Number 9. Casey Anthony Murder Trial Verdict. By July 2011, the case felt like a national TV event with an ending already written. The state charged Casey Anthony with first-degree murder and other serious counts tied to the death of her daughter, Kaylee. For many viewers, the evidence sounded damning, but the courtroom standard was different. Every element had to be proven beyond a reasonable doubt. On July 5, 2011, after deliberating for about 10 hours and 40 minutes across 2 days, the jury acquitted her of the most serious charges, including first-degree murder, aggravated manslaughter of a child, and aggravated child abuse. She was convicted on 4 misdemeanor counts of providing false information to law enforcement. The defense did not need a miracle witness. The win came from the state failing to lock down a clear cause, timeline, and intent that 12 jurors could unanimously accept. Number 8. People vs. Dan White, the Twinkie defense moment. The facts were brutal and undisputed. On November 27, 1978, Dan White shot and killed San Francisco Mayor George Moscone and Supervisor Harvey Milk. The fight was not whether he did it, but what was in his mind when he did it. In 1979, the defense leaned into diminished capacity, painting a picture of depression and a life collapsing. During the trial, satirist Paul Krasner, reporting for the San Francisco Bay Guardian, coined the nickname Twinkie defense, and the phrase stuck to American memory. The verdict landed on May 21, 1979. White was convicted of voluntary manslaughter rather than murder and sentenced to 7 2/3 years. It felt impossible to many people watching because 2 public assassinations looked like an automatic murder conviction. But one legal distinction, premeditation, became the crack the defense escaped through. Number 7. Harvey Weinstein, New York reversal and retrials. A landmark verdict can still unravel if a judge lets the wrong evidence through. On April 25, 2024, New York's highest court overturned Harvey Weinstein's 2020 conviction in a 4-3 decision, saying the trial was prejudiced by rulings that allowed testimony about uncharged allegations. It was not a new alibi, it was the rule book applied late. That decision set off a chain reaction. A 2025 Manhattan retrial produced a split result: a conviction on the Miriam Haley criminal sexual act count, an acquittal on the Kaja Sokola count, and a deadlock on the Jessica Mann third-degree rape count. On April 21, 2026, opening statements were set to begin in yet another New York retrial on that unresolved count after jury selection the previous week. The defense did not win by charming a jury. It won because the original courtroom allowed material that appellate judges said never should have entered the story. Number 6. Commonwealth versus Cosby. A conviction can look permanent until a promise from years earlier comes back to haunt the prosecution. Bill Cosby was found guilty on April 26, 2018 in Pennsylvania, and on September 25, 2018 he was sentenced to 3 to 10 years in state prison. For the public, it read like the end of the legal saga, a famous man finally held to account through a criminal verdict. Then the case flipped on procedure, not persuasion. On June 30, 2021, the Pennsylvania Supreme Court vacated the conviction. focusing on due process and a prior prosecutor's commitment that Cosby would not be charged, a decision that helped lead to testimony later used against him. Cosby was released that day. The court was not reweighing guilt. It was punishing a process that, in its view, broke the rules. Engagement break. Before we continue, which legal twist hit hardest so far? The glove demonstration, the appellate reversal, or the surprise acquittal? Did you watch any of these unfold live on network TV? Drop a comment and let us know where you are watching from. Number 5. Alec Baldwin, Rust manslaughter case dismissed. Most criminal trials end slowly, one witness at a time. This one ended like a trapdoor opened under the prosecution. On July 12, 2024, during Alec Baldwin's involuntary manslaughter trial in Santa Fe, Judge Mary Marlowe Summer dismissed the case with prejudice after finding a Brady disclosure violation involving evidence about live ammunition. The defense did not need to win the jury. It won the judge. The dismissal carried extra force because it came mid-trial, with the jury already seated and the spotlight at full brightness. Prosecutors filed a notice of appeal in November 2024, but the New Mexico Attorney General's office declined to pursue it, and the special prosecutor withdrew the appeal on November 25, 2024, solidifying the dismissal. The accidental win was not a clever speech. It was the state mishandling evidence in a way the judge ruled was fundamentally unfair. Number 4. Duke lacrosse case collapse. Before the facts fully surfaced, the story had already gone national. In 2006, members of the Duke University men's lacrosse team were accused of rape, and the case exploded into a media storm that treated accusation as conclusion. Defense lawyers kept pressing on one unglamorous point: what the evidence actually showed, including DNA results and what the prosecution was doing with them. On April 11, 2007, North Carolina Attorney General Roy Cooper dropped all charges and publicly declared the accused players innocent, saying the cases were the result of a tragic rush to accuse and a failure to verify serious allegations. The local prosecutor, Mike Nafong, became part of the story, not the storyteller. On June 16, 2007, a North Carolina state bar panel disbarred him for misconduct. The defense win came less from theatrics and more from insisting the state play by its own rules. Number 3. United States versus Ted Stevens. A sitting United States senator stood convicted, and the political clock moved faster than the legal one. Ted Stevens was found guilty on October 27, 2008 of failing to report gifts, and the fallout helped cost him re-election days later. To the public, it looked like a rare, clean takedown of power. Inside the case file, the story was messier. In early 2009, the Justice Department reviewed the prosecution and found serious disclosure problems. On April 1, 2009, Attorney General Eric Holder moved to set aside the verdict and dismiss the indictment. On April 7, 2009, Judge Emmett Sullivan granted that request, wiping away the conviction. The defense did not suddenly discover a new fact. It benefited from prosecutors failing to turn over information that could have mattered to a jury. Number 2. Malaysian identical twins drug trafficking acquittal. Some defenses are built on witnesses and timelines. This one was built on a mirror. In Kuala Lumpur, identical twins R. Sathis Raj and R. Sabarish Raj faced drug trafficking charges tied to a 2003 incident. By the time the case reached its decisive moment, the court confronted a nightmare scenario. Evidence suggested one twin was guilty, but the system could not reliably prove which twin it was. On February 6, 2009, High Court Judge Zahara Ibrahim acquitted and discharged both men, describing the situation as a very unique case and refusing to risk convicting the wrong person. Even DNA could not separate identical twins in a way that solved identity beyond doubt. It was the purest version of an accidental win because it was not a brilliant argument. It was the prosecution being unable to name the correct defendant with the certainty the law demands. Number 1. O'Connor versus Oakhurst Dairy. A single missing comma turned into a $5 million lesson in how laws actually work. In Maine, dairy delivery drivers sued Oakhurst Dairy over overtime, arguing that the wording of an exemption was ambiguous. On March 13, 2017, the First Circuit reversed a decision that favored the company, leaning on basic statutory interpretation and the principle that wage laws are read narrowly against exemptions. The satisfying part was how ordinary the weapon was. No surprise witness, no courtroom meltdown, just careful reading. On February 8, 2018, 127 drivers reached a $5 million settlement. The company did not admit wrongdoing, but the outcome made history anyway. In a world where people expect justice to arrive with drama, this win arrived with punctuation, and it ended with paychecks.